Hi. So, whenever there is a complaint registered against you by the police, the routine course of the police is to investigate the ingredients of the complaint, whether they are true or false. And if it is true, they file a charge sheet, which is a positive report. If it is not true, they file a negative report, which is called final report in the court. So, in the process of this investigation, if you are the accused, you may be arrested or you may not be arrested. There are many guidelines regarding arrest. I will not go into detail in those guidelines. I limit myself to a point where you don't need any bail application at a certain point. So in the process of investigation, police may arrest you, police may not arrest you. Let us presume police did not arrest you. Police issued some notice or did not issue some notice and they completed the investigation without arresting you. Now they submitted the report before the magistrate. Once the report is submitted before the magistrate, the magistrate applies his mind, reads the FIR, reads the complaint, reads the investigation report and all the statements of the witnesses, and comes to a conclusion whether the accused must be arrested or not. If the magistrate comes to a conclusion that the accused need not be arrested, he will issue a summons to appear. Police will deliver the summons to the accused and deliver it by hand under acknowledgement, and the accused will appear in the court. What if the magistrate issues a warrant directly? It is purely the discretion of the magistrate to issue the summons or warrant. If the magistrate issues a warrant, what happens? Warrant means the power that is given to police to arrest and produce the accused before the magistrate for the purpose of trial. At that point of time, police arrests the accused based on the warrant issued by the magistrate. The warrant was based on the report filed by the police, and the accused is produced or made to appear before the magistrate based on the warrant with the remand application. So while arresting the accused, there will be procedure that is to be followed. I am not going into that. Now, when the accused is arrested for producing before the magistrate, then there is a process of submitting the bond or surety for ensuring the presence of the accused in the entire trial. At that point of time also, accused can appear for bail. Accused can apply for bail. So for applying bail at that point of time, that is the first appearance in the court, there is no need of any separate application is the sum and substance of the Supreme Court interpretation of section 204 CRPC, read with section 88. So section 88 deals with submission of bonds and sureties. Section 204 deals with the appearance of the accused. So when the accused is appeared before the magistrate for the first time, he can be granted bail without any separate application. So that is the sum and substance of this video. Thank you. Thanks for watching. If you have any doubts, kindly comment.